I'm Chris Schrader. I'm the director of the program in public law. The program, for those of you who might not be familiar with it, is happy to sponsor events like this and other activities throughout the school year that discuss and critically analyze important issues in the development of constitutional law, ethics, campaign finance, and really any topics, matters that affect the duties and responsibilities of public officials. I'll drop a commercial announcement here, just a brief one, for an event we're holding a week from today in this same room, I believe, at the same time, which will be our annual review of last year's term of court, reviewing some of the significant decisions from last year. A panel of three of your Duke faculty will be doing that. And then in the first week of October, we'll have also an annual tradition, a preview of the upcoming cases that are on the docket so far at the court. Today, I'm happy to introduce the inaugural of a series of lectures that will run through the fall on the general theme of lessons learned. 8 years ago, when President Clinton was leaving office, the very first major event that the program in public law sponsored here was a conference, a multi-day conference on the Clinton administration and the Constitution. What had changed in terms of constitutional doctrine during those 8 years, how the Clinton administration had influenced those changes, what influence had they had on our constitutional discourse and agenda. So with the Bush administration now drawing to a close, we wanted to do something similar, but decided instead of a multi-day conference that we do a series of lectures spread out through the semester, each one on some aspect of that general topic. Now, there are many ways that the president can affect constitutional discourse, not all of them focused on the federal courts. If anyone needs proof of that, recent controversies over the extent of the president's authority to engage in warrantless wiretaps, to sanction interrogation techniques that have been prohibited by Congress, to withhold testimony of key aides from the committees of Congress, all of which may well avoid any definitive resolution by the courts, should be proof of that. Having said that, the power of the president to nominate individuals to the federal courts, and especially the Supreme Court, undoubtedly is one of the most important ways that presidents influence constitutional law and constitutional discourse. So today we start our Lessons Learned series with the Supreme Court and with a speaker who is exquisitely qualified to speak on the topic. Today's lecturer has observed constitutional decision-making from inside the executive branch, both in positions at the Office of Legal Counsel at the Justice Department and as an assistant to the Solicitor General of the United States. He's observed it from the congressional angle as a special counsel to the Senate Judiciary Committee during the nomination of David Souter to the Supreme Court. He's observed it as an advocate, having argued before the Supreme Court 18 times, and he's observed and written about it and contributed to the discourse as one of the country's most distinguished scholars, writing and thinking about constitutional law and constitutional theory today. So together with the program in public law and the Constitutional Law and Policy Journal, which will be publishing each lecture in this lecture series, please join me in welcoming David Strauss, the Gerald Ratner Distinguished Service Professor of Law at the University of Chicago.
Thanks a lot, Chris. Well, thank you very much, Chris, and thank you all for having me. I'm honored by the invitation to give the inaugural lecture of this series. The title of my particular lecture is The Death of Judicial Conservatism. Now, I know if we're talking about the lessons learned in the Bush administration and the outcome of the Bush administration, that sounds like it's either a misprint or maybe the diluted ramblings of a liberal who didn't get the memo. I mean, I'm a liberal, and I guess when you're deluded, you don't know you're deluded, but just stick with me for a minute, and I think it is neither of those things. I think it is an accurate description of one of the things that history will say about the Bush administration's appointments to the Supreme Court. Now, to say that judicial conservatism has died is not to say that its opposite, liberalism or a progressive vision of the Supreme Court, is somehow alive. I think it is clearer than ever that people who hoped for a revival of the Warren Court, of a court that had an agenda to be at the forefront of social reform in a generally liberal or progressive direction, that people who had that hope had better give it up, at least for a generation. I think that's an obvious lesson of the Bush appointments. These were appointments of two justices who, by Supreme Court appointee standards, are young. They're also very good, they're very distinguished, extremely able lawyers, both the Chief Justice and Justice Alito. And the other things that became clear in the course of their appointment is that the judicial appointments process, when a Republican is president, is being controlled by a wing of the Republican Party that is very deeply conservative, very deeply committed to conservative principles, and very deeply committed to making sure that judicial appointments carry out those principles. This is not a judgment. I think it's just a fact. Parties are entitled to arrange these things as they see fit, and there have been examples of that on the other side of the spectrum. But I think that's an accurate description of one thing that we saw in the Bush administration. When President Bush tried to appoint his counsel, Harriet Miers, to the Supreme Court, he was rebuffed not by the Democrats, but by people in his own party who were concerned about whether she was sufficiently, quote unquote, reliable, and also, in fairness, concerned about her competence, or competence is too strong a word, about whether she was at a level of distinction that would warrant her appointment to the Supreme Court. President Bush was following a tradition in appointing someone close to him. You know, every president wants to be like Harry Truman. Harry Truman appointed nothing but his own cronies to the Supreme Court. And so I guess President Bush is trying to be like Harry Truman, but this time his party didn't want him to be like Harry Truman. So that's the picture. The other part of the picture is that it certainly looks as if the Democratic Party did not have either the inclination or the ability to fight these appointments, to try to insist that appointees be more toward the center of the spectrum, or more or less clearly chosen for their conservative record. So put all of those things together, and the idea that there might, as I said, the next generation be a revival of something like the Warren Court, a court with a progressive vision, I think that is very clearly not going to happen. But that's obvious. The unobvious thing that I'm going to try to convince you of is that we're also dealing with something that can fairly be characterized as the end of judicial conservatism. Well, how can that be? How can it be that if the liberals have been vanquished, the conservatives have not triumphed? I think the way to begin thinking about that question is to ask yourself, okay, judicial conservatism, what is it exactly? What does it mean to be a conservative Supreme Court justice? Let me start with three things that it can't be, although they're often identified with that view. One is, well, if you're a conservative, you follow the original understandings. You follow the intentions or the understandings of the people who drafted or ratified the Constitution, or how the Constitution was understood at the time its various provisions were ratified. Those are variants on the same view, immaterial for these purposes. The reason that doesn't work is that view of constitutional interpretation, well, there are a couple reasons. One is that view of constitutional interpretation has actually, in fact, just been discredited over and over again, beginning with James Madison and Thomas Jefferson. It's not a new idea that you cannot interpret a document so as to give voice to the intentions of people who've been dead for a couple of hundred years, that is not doable, and even if you could do it, it would not be a good idea. The evidence of this, it's obviously a longer story, but the evidence of this, two pieces of evidence worth mentioning. One is that originalism is by no means something that historically has been identified with people who are called conservatives. The most influential originalist judge of the last 100 years was not a conservative at all. It was Hugo Black, Justice Black, appointed by Franklin Roosevelt, a mainstay of the Warren Court. He was far more influential in carrying out what he saw as the original understandings than any of the present-day conservative originalists. So this is not a distinctively conservative view. It's not a distinctively liberal view either. I think it is a matter of people who are holding views for other reasons enlisting the framers on their side. If you want a little bit more evidence of this, of what's going on with originalism, the two Bush appointees, since those are the people we're focusing on, the two Bush appointees show no signs of being tempted to be originalists. In their confirmation hearings, they did not espouse that view. I think the Chief Justice Roberts actually did not ever in his confirmation hearing say something like, I believe the Constitution should be interpreted according to the original understandings. He never said that. Justice Alito, I think, made a fleeting reference to it in a list of things that he would take into account. But neither of them said, well, this is my view, as Justice Scalia and Justice Thomas on the court will say. So I think this sort of engagement with originalism was something that proved useful to conservatives at a certain phase, just as it proved useful to Justice Black at a certain phase, and we're now past that phase. And this is not what judicial conservatism is any more than it's what judicial liberalism is. Okay, so that's one thing that judicial conservatism really is not. It's not a matter of conservatism dying or not being present. That's just not a plausible or coherent view. Second thing that it's not, that you hear sometimes, strict constructionism. Well, conservative is a strict constructionist. Okay, well, what does that mean exactly? Strict constructionist, and what is the antonym? What are people who are not strict constructionists? If strict construction means, well, I follow the law, well, everybody says they follow the law. If strict construction in our history once did have a fairly clear meaning back in the early days of the Republic, when it meant that the powers of the federal government would be narrowly understood. That was the Jeffersonian understanding in his opposition to Alexander Hamilton and Hamilton's allies, who thought that the powers of the federal government should be given a more expansive understanding. Jefferson's view was no, they have to be confined narrowly. That was a coherent, whether it was right or not, coherent view of what strict construction means. The federal government's powers should be limited. But that, I think, is not, I'll return to this, that I think is not where today's conservatives are going. By strict construction, I think usually what they mean is, we think Roe against Wade was wrong. I think that's what they mean. Now, it's fine to think Roe against Wade is wrong. I mean, lots of reputable people think that, and that's an important and a complex discussion to have. But then say that, and don't say strict construction. Okay, the third thing that conservatives, judicial conservatism might be thought to mean that just doesn't work is just follow the law, just decide the cases. Why do we need all of this ideology? Why do we need all these labels? Just the cases come before you, be a good lawyer, decide the cases. There's something to be thought about here, and I'll actually return to this at the end of my remarks. But for now, the thing to bear in mind, I think, is that the Supreme Court is dealing with cases where good lawyers, almost always, where good lawyers disagree about what the right answer is, or can disagree. There are plenty of questions where good lawyers will all agree on the answer to the question. You just cannot give anything but one answer to that question and be a good lawyer. That has to be true, because if it weren't true, how could the likes of me and your teachers give you grades, right? If it was just all up for grabs, and now you can make this argument, you can make that argument, it's all the same, then you and not to mention my students, I can say this because they're not here, should be an open rebellion. But it's not true. There are plenty of things on which good lawyers will not disagree, which there's only one answer that a good lawyer can give, but virtually none of those things make it to the Supreme Court. They don't get litigated, they get settled, they get decided by the lower courts. The Supreme Court doesn't take them. It's not quite true, but it is almost true that any case in the Supreme Court, certainly any high-profile controversial case in the Supreme Court, good lawyers can disagree without stopping to be good lawyers. So just saying I'm going to decide the case the way a lawyer would only gets you so far and does not get you the resolution of the answers to the Supreme Court cases that get the headlines, that attract the attention, and that are by and large, most important for the country. You need something else. You need some kind of vision, some kind of sense of fairness, some kind of idea of where the country should be going or where the court should be going or what role the court should be playing. You need something else to decide those cases besides just good lawyering. In fact, the way I would put it is a part of good lawyering is to have that sense of whatever it is, fairness or justice or the role of the court. And I'll return to this in a second, but for now the point is it's not enough just to say, well, a judicial conservative is someone who decides the case in a lawyer-like fashion. Everybody up there is deciding cases in a lawyer-like fashion. That's not really the issue. The issue is what does that mean when you get to the point where good lawyers disagree? Okay, so now let's think about some things that judicial conservatism might be, if it's not those three things. Well, one thing it might be, a time-honored view, is what could accurately be called judicial restraint. Judicial restraint usually as opposed to activism. When you talk about those things, you're at the risk of just engaging in rhetoric and labels. But judicial restraint can be given a coherent idea, and there was a view that was very clearly and forcefully articulated at one point in our history. The view would be that the courts should not overturn the actions of the people's elected representatives, except in extreme cases. If Congress or the state legislatures do something truly irrational or truly indefensible, then, but only then, should the courts step in and declare it unconstitutional. The rule of the clear mistake, as it's sometimes characterized. It has to be a clear mistake by the elected branches of government, or else the court should stay out. The most prominent proponent of this view in our history by far was Justice Frankfurter, Felix Frankfurter, a Roosevelt appointee. The canonical opinion on this subject, I'm not 100% sure what canonical means, but it seems to me if you're giving a lecture like this, you ought to say canonical at some point. The canonical case on this point is a dissent Justice Frankfurter wrote in a case called West Virginia State Board of Education against Barnett. In Barnett, the Supreme Court, a majority of the Supreme Court, in fact, everybody but Justice Frankfurter voted to strike down a West Virginia law that required school children to say the Pledge of Allegiance. Justice Frankfurter dissented. He said, wrote a very emotional, a very personal dissent, talking about how he was a member of a persecuted minority. He was Jewish. So he certainly understood the position that these school children were in, but he simply did not think it was the court's job to strike down this law if it was the judgment of the people of West Virginia that the school children should be saying the Pledge of Allegiance. That's judicial restraint. A very clear disapproval of the law, a perfectly plausible argument that the law was unconstitutional, but because it was not overwhelmingly clear that it was unconstitutional, Justice Frankfurter thought it should be upheld. I think it is fair to say that since Justice Frankfurter, even Justice Frankfurter didn't hold this view consistently by any means throughout the course of his career on the court. Certainly since he left the court in 1962, the number of justices who have held this view with anything remotely approaching consistency is zero. Nobody. Certainly nobody on the court today holds this view. There are plenty of instances in which every justice who has sat since Frankfurter, including Frankfurter, in fact, has voted to declare unconstitutional measures where it was not obviously unconstitutional. It was fairly arguable. And we're all just accustomed to the idea that that's what the court does. So this is a possible view. We could go back to this view. It has some academic advocates of saying the court should basically recede to the background on constitutional issues, only act in truly extreme cases. If some it's hard to imagine Congress doing this. Perhaps it's possible. It's more likely it would be some local government or conceivably a state government doing something that just makes you sort of shake your head in embarrassment and amazement that they could do such a thing. Okay, then, but only then the court should step in. But that's not in the picture. That is certainly not the two most recent appointees or any of the other so-called conservatives on the court. It's not the so-called liberals on the court either. But if you want some examples, there are plenty. Two provisions of the McCain-Feingold Campaign Finance Reform Act have been struck down by the court with the Bush appointees in support, leading the charge in the case of one of them. Chief Justice Roberts wrote an opinion saying, when in doubt, I'm paraphrasing, when in doubt we should err on the side of protecting political speech. exactly the opposite of the judicial restraint doctrine. If you're in doubt and it's a First Amendment claim, it involves freedom of speech, political speech, strike it down. The opposite of this judicial restraint doctrine. There are plenty of other examples, the most dramatic one recently being Heller, the Second Amendment case about the right to bear arms, certainly a fairly arguable issue at most. The Supreme Court struck down the District of Columbia ordinance on a 5-4 vote, despite the plausibility of the arguments in both directions. Maybe that decision was right, maybe that's wrong. That's another argument we can have, but it's certainly, it and many other examples are certainly enough, some of which I'll mention later, certainly enough to dispel any idea that the form of judicial conservatism we have is that kind of severe Frankfurter-like judicial restraint. Okay, if it's not judicial restraint, then what? Well, how about federalism and states' rights? That's another view that judicial conservatives have from time to time embraced. That what the court is there to do is to protect state and local governments, the forms of government closest to the people, from the overbearing, overarching, remote federal government. That's what conservatism consists of. There were hints in the Rehnquist court that the court was going to go in this direction, of course. Celebrated cases in which the court, reversing a trend that had existed since the New Deal, struck down acts of Congress on the ground that they exceeded Congress's power, and it looked as if the court might be moving toward this view of its role, that its job is to protect the rights of state and local governments, or the prerogatives of state and local governments, against federal intrusion. This is a little bit speculative, but I'm pretty confident in the speculation that that thrust, that impetus, has essentially disappeared from the scene. The two people who believed most strongly in federalism have both left the court, Chief Justice Rehnquist and Justice O'Connor. Their replacements, judging by their careers, which have been in both cases exclusively federal careers, and judging by their writings on the lower courts, are not committed to federalism in anything like the same way. And the evidence the most dramatic evidence that this protection of local prerogatives is not what this so-called conservative court sees as its mission. That is to say that this is not the form of judicial conservatism that we're seeing. The most dramatic evidence of that for me are the cases decided a year ago involving the efforts of a couple of local school boards to integrate their schools. The school boards in these cases used racial criteria in order to bring about school integration. The Supreme Court said that what they were doing was unconstitutional. The two Bush appointees voted with the majority, and Chief Justice Roberts wrote the prevailing opinion, a fairly strongly worded prevailing opinion. Now think about it for a second. Here you've got local school boards addressing a local problem, an intensely difficult local problem having to do with sensitive issues of education and racial dynamics, using their judgment and deciding that they wanted to address the problem in a certain way. And the Supreme Court in Washington telling them they couldn't do it. Now, again, maybe it's right, maybe it's wrong. I guess I'd probably tip my hand about what I think, but that's another conversation. But one thing you cannot say is that that is a court that cares deeply about local prerogatives and protecting local governments from the intrusions of the federal authority. You just can't say that. You might want to say, look, there are times when local prerogatives have to yield to a moral or constitutional imperative. You can say that. But you cannot say that those are cases that were decided by a court that puts at the top of its list protecting local governments against federal intrusion. What makes that example particularly dramatic, I think, is that in those cases, there were two cases, there were a series of cases in the lower courts, two of which the Supreme Court decided. In two lower court cases, self-identified conservative judges, prominent conservative lower court judges, wrote opinions upholding the school plans, saying pretty much what I just said. That is, look, this is an effort, a serious effort by local authorities to address an intensely local problem, and they're doing it in a way that obviously they thought about. We should, if judicial restraint means anything, these judges said, we should let them do it. That opinion was unequivocally, without any apparent second thoughts, rejected by the majority on the Supreme Court. So here you had an articulation of a particular conservative view. We may not like race-conscious decision-making, but we believe more strongly in allowing decisions to be made by the bodies of government closest to the people, and we, black-robed federal judges working in some remote place, out of touch with local problems, shouldn't be stepping in to tell them what to do. That vision was articulated by the lower court judges, Judge Boudin and Judge Kaczynski, both prominent conservative judges by any popular accounting, and as I said, squarely repudiated by the Supreme Court without any sort of compromising language that, yes, we understand the point, we just think it doesn't apply here, nothing like that. There are other examples as well. The gun control case is an example of that. I think the court doesn't seem to be moved by the idea that this is another issue that should be resolved on the national level rather than constitutionalized. But for me, at least, the affirmative action cases, the race-conscious school integration cases are the clearest examples. Okay, so if it's not judicial restraint of the clear mistake kind, if it's not protecting local governments, what else might judicial conservatism be? Well, here's something else it could be, and something else that it seemed like it might be for a while. It might be a libertarian view. That is to say, the conservative view might be, look, the role of the courts is generally to keep government in check. Federal government, state government, local government, doesn't matter. The threat to individual freedom comes from government, and the court's role, the court's distinctive role, is to protect individuals against government overreaching. That's what we should be doing. That's what a judicial conservative does. That's, again, a coherent view. There are lots of things you could debate about just how far it should go and just why the court should be in this business and so on and so forth, but it is a coherent view, a coherent role for the courts to play. There were glimmerings in the Rehnquist court era that the court might be moving in this direction. But again, a lesson of the Bush years, I believe, is that is not what judicial conservatism is. And here Exhibit A is this last term's decision in Boumediene, the case involving the detainees imprisoned in Guantanamo. Now, of course, the court declared the statute under which they were being held, or the statute that more precisely that regulated their rights to seek relief from being detained. The court declared that unconstitutional, but there were 4 dissents, including the 2 Bush appointees and the 2 people, Justice Scalia and Justice Thomas, who President Bush took as his ostensible model for those appointees. So if those are your conservatives, they were not in the majority in Boumediene. They did not have a problem with what the government was doing in that case. And here's why I think that it's a particularly dramatic case, or a particularly illustrative case, if you think that judicial conservatism means the courts ought to be protecting individual liberty. That was a case in which the executive branch of the government made a deliberate decision to hold people in a way that would escape judicial scrutiny. The reason those people are in Guantanamo is because the government wanted to keep them in a place where it could control them completely, but where lawyers in the executive branch thought the court's writs would not reach. It was just far and enough so that if you're holding an alien there, they cannot assert their rights under the Constitution, but not so far in that we would have, as a practical matter, problems controlling what went on. That was the explicit rationale for holding them in Guantanamo, to escape judicial scrutiny, instead of bringing them on shore. Now, again, as far as, was that an acceptable thing, a sensible thing, an admirable thing, a necessary thing for the government to do in dealing with people, suspected terrorists, picked up on battlefields and so on? Maybe so, maybe not. That's a much more complex debate. But if you're a libertarian judge, if you're a judge who thinks, okay, I'm a conservative, and what conservative means, if you're a judge, is I'm suspicious of the government. That's my role. My job is to be suspicious of the government and to step in and protect individuals when the government overreaches. That should be a clear case for you. That should be a case in which you will say, wait a second, no. One thing you cannot do is effectively disable the courts from protecting individuals. As far as what level of protection they should get, that's something that has to be worked out. But if your idea is the role of the courts is to protect individuals from overreaching on the part of the executive and legislative branches who get too caught up in their own missions, trample on individual rights. We judges are here to prevent that, and we're going to prevent it whether it's detainees in Guantanamo or small business owners in Durham who are being interfered with by the regulatory state. If that's your, and that would be the coherent libertarian view. If that's your view, you should find it intolerable for the government to do what it did in Boumediene. These conservatives did not. Were they wrong? As again, a different conversation. A pretty difficult question, I think. But one thing you cannot say is that they are libertarian conservatives on a hugely important issue, a big issue of our time. Their reflexes, not reflexes, their considered judgment was all in the other direction, all in favor of giving deference to the executive branch. Maybe that's right, maybe that's wrong. It's not libertarian. Okay, if conservatism in our era, in the Bush era, is not judicial restraint, and it's not protecting states' rights and local government, it's not federalism, and it's not libertarian, what is it? Well, that's my point, I guess, that we are left with a conservatism that, while it calls itself conservative, is unable to articulate any coherent conservative creed. It takes a variety of forms, a variety of reactions against what were seen as the excesses of previous courts, some of which may have been excesses, some of which probably were not excesses. But as far as a coherent view that this is what the court should, if you're a conservative, you think the court should be doing this, there's no answer to that question. That's I think, a lesson that has emerged from this, from the Bush era. Okay, so what? So what? Who cares? So judicial conservatism isn't anything coherent. It's just we kind of know that Justice Scalia and Justice Thomas and Justice Alito and Chief Justice Roberts are conservative, and we kind of know that some other people on the court are at least more liberal, and we kind of know that Justice Kennedy's in the middle. Who cares that we can't, as observers, articulate a coherent, or they can't articulate, we're not asking them to articulate, they don't act out of a coherent view of what conservatism is. Isn't that just kind of something for people in the academy to play with? Oh, this is their vision of the court's role, and who cares if they have a vision or not? This brings me back to one of the places that one of the things I started off with as far as views that just don't work. Why can't they just decide the cases? Just decide the cases. Why do they need a vision? Why do they need a coherent idea? Cases come before them. They look at the cases. Yes, okay, someone might say, I take your point. You can't just decide the cases on the basis of lawyers' law. When they get to the Supreme Court, there's going to be an element of them that requires you to think about fairness or economic efficiency or something like that. Fine, that's fine, but that's what they'll do. They'll just make that judgment. Who cares if it's not coherent? That's a powerful view, but in the end, I think it is a view that should raise serious questions about the legitimacy of the Supreme Court's current role in our system of government. Because when I talk about a coherent vision by conservatives, or if we were in another era, the question would be raised about liberals. It's just as I said, if conservatism is dead, liberalism, judicial liberalism, is dead as a doornail, the proverbial doornail. We could be talking about that in another era. The coherent vision is an answer to a question, why exactly is it that the Supreme Court gets to second-guess the judgments made by the people's elected representatives? What exactly are they doing? And if you have a vision, you've got an answer to that. You can say, well, I'll tell you what they're doing. The political system tends to centralize power too much. And you need some people out there who are going to look after the prerogatives of state and local governments. There's an answer. Good answer, bad answer, another discussion. But you've got an answer. Or you can say, well, I'll tell you what they should be doing. In a liberal era, you might say, there are people who just don't get their fair shake in the political process. Dissenters, racial and religious minorities don't get a fair shake, criminal defendants. And what the courts ought to be doing is sticking up for them. That was essentially the Warren Court vision. And again, we could have an argument about what do you mean don't get a fair shake? What are the courts doing deciding that? And various other questions you could ask, but at least that's an answer to the question, what are courts doing striking down laws? You could say, on a libertarian view, well, I'll tell you why the court should do something. Governments tend to accrete power. They tend to see things in terms of the exercise of their own power, and if you're a legislator, or especially if you're in an executive branch position at the federal level or at the state level or at the local level, you tend to see things through that lens and not give enough weight to the rights of individuals, and that's true whether you're locking people up or regulating their businesses. And that's what judges should do. They should step in to protect individuals. Now that's an answer, and again, plenty to debate about. But my argument has been today's conservatives don't have an answer to that question. That's what it means to say they don't have a coherent view. Now, does that matter in the end? Well, I will say yes, but as a matter of judgment rather than prediction. I think if you are concerned about whether the court has a justification for exercising power despite the fact that its members are unelected and serve for life, if you're concerned about that, then you ought to be concerned about the lack of a vision. You ought to be concerned about questions that could be raised about the legitimacy of what the court is doing. Should it be doing what it's doing? Is it right? Is it justified? Will we get to a point politically where people will raise that question in large enough numbers so as to undermine the Supreme Court's authority? Who knows, of course. I kind of doubt it. I mean, the fact that there is a question doesn't mean that the question will have these political ramifications. And in fact, over the last generation or so, the justices on the court have proved very adept, surprisingly adept, at playing politics, really, at doing enough so that neither side of the political spectrum can really get that mad at them and try to delegitimate them. And maybe they'll continue to perform that kind of very political balancing act. But the question remains, as we enter into what I think will be a generation of solid judicial conservatism, just what is it? And if there is no answer to that question, no coherent answer to that question, what are they doing exercising that power? Okay, thank you very much.
Thanks, David. We've got time for some questions. Yeah.
Not my opinion disguised as a question. Do you think that this lack of a prevailing ideology on really any part of the Supreme Court might have something to do with the fact that since Roe v. Wade and similar decisions, the decisions for who goes on the Supreme Court has a lot to do almost with a rough approximation of what the majority, it's like the majority elects the president appoints the Supreme Court, and the president appoints these people to overrule these decisions. And do you think that the rise of that kind of thinking of appointing people to overrule decisions as a proxy for majoritarian problems with those decisions might have something to do with the fact that we don't have a prevailing ideology because the people, you see what I'm saying?
Yeah, I do see what you're saying. That's a very good question. Let me just sort of recouch it a little bit, because I'm not sure these people are appointed to overrule Roe against Wade. We haven't had anybody get confirmed who would say, yes, I will vote to overrule Roe against Wade. They don't say it. But that's a cavil. That's a small point. I think underlying your question is a terrific idea. So the idea would be something like this. Tell me if this is a fair rendering of your idea. Look, you're only going to get coherence when the appointments process is not high visibility and is not politicized. Because people with a coherent sort of, here's what I think, take it or leave it, will be told, no thanks, we'll leave it. That you're going to get appointees who are basically kind of political, know how to play both sides, know how to say the right thing, that the process is basically loaded against people with a vision. That may very well be true, and it is the case that the appointments process, of course, has been very politicized in the last 20 years or so. It's a terrific idea. The only reason I hesitate a little bit about endorsing it, and it may very well turn out to be exactly right, is that you have seen courts in the past appointed at very intensely political, when there's a lot of attention paid to the court. You have seen courts in the past with that kind of vision. The Warren Court, not so much. The Warren Court came out of a time when the appointments process was not particularly high visibility, and is really a great data point for your claim. But the Marshall Court had an idea that their idea was sort of an anti-federalism idea, that the Supreme Court is there to protect the federal government against the inroads by the states. Very clear vision. And that was intensely political. a time. And possibly during the progressive era when you had the infamous Lochner Accord, which also had a vision, again, a vision that's been repudiated, but a vision, was also a pretty political time. So I'd want to think some more about possible counterexamples, but it strikes me as an extremely plausible hypothesis. Thanks.
So none of the conservative members have a coherent philosophy. Do you think the liberal wing or any member of that wing has a coherent worldview?
No, probably not. Another reason you could add to the list of why we won't see a revival of the progressive vision on the court, in addition to the dominance of conservatives currently and the unwillingness or inability of the Democratic Party to invest political resources in the composition of the court. You could add to it the fact that the progressive vision is lacking an intellectual leader on the court. The closest that it comes to such a person is Justice Breyer, I think, who's at least tried to articulate a view, but I'm not sure his view is successful, maybe. But we're not dealing with, one thing the Warren Court had was intellectual leadership from Black and actually from the not very intellectual Chief Justice himself, who had instincts about what he was there to do, Chief Justice Warren. And the liberal wing of the court does not have that, I think.
This may be a little crass, but like, why assume that there's a difference now between judicial conservatism and political conservatism? I mean, if their opinions line up with political conservatism, which is why they're appointed that way, or at least the last two justices.
Yeah, I mean, you're being more, was crass? Was it?
I think so, yeah.
Said, then I was willing to be. But you could say, yes, you could say, look, I'll tell you what conservatism is in our age. It's the political agenda of the Republican Party. That's what it is. To a degree, yes. Maybe not entirely. I guess the reason I wouldn't emphasize that is that the point I was trying to make at the end would still stand, which is you've got to explain what you're doing being a life-tenured judge appointed without a political check, implementing an agenda. And if all you're implementing is the agenda of a political party, what's your excuse? That's, let them win elections. So if that's the conservative view, then it is not an answer to the question, what are judges doing exercising this power? It's a little uncharitable, I think, to say just that, and we don't really have enough evidence, at least of the two most recent appointees, who may branch off from that agenda in interesting and important ways. But if that's all they have, then my question remains.
I thought I saw a hand.
Here.
I'm ignoring my colleagues from to try to encourage student-lecturer exchange. Yeah.
If I can test your theory against two current events, one being that the next president is likely to appoint 3 or possibly 4 justices, and 2 being the global war on terror, which continues to test the court in, I'll say, an uncharted way, but in new and challenging ways. How will those 2 events either change the court, or how will they test your theories about either the death of conservatism, the rise, the possible resurrection?
Of conservatism, or?
Sure, of a theory in general of conservatism.
I guess I would. I mean, it would be a separate question about what the lessons of the next administration. I guess I would be surprised to see any dramatic change on the issue of what does conservatism look like. I wouldn't expect to see a coherent vision emerging from a McCain administration on this point. If anything, you would expect, this administration, which had among its constituencies a core of conservative intellectuals, you would expect, okay, this is where you'd see it to a greater extent than with someone whose administration is not likely to be in tune with kind of the rigorous intellectual core of the conservative movement. So I wouldn't expect that to change. Also, I think, this, to some extent, the incoherence, if I'm right in characterizing it that way, of conservative thought is a response to these political pressures. I mean, the reason you don't see a consistent localism or consistent federalism, for example, is because, the people in the Republican Party don't want conservatives upholding local affirmative action plans. They don't want deference to local governments. The reason you don't see a consistent libertarianism is that people don't agree that individual rights should be expanded to that extent. So I wouldn't expect to see any change in either direction. I don't think, I think if you look at the key elements of the Democrats' agenda, they are not court-centered things, except for choice, which is kind of a negative agenda item. They want to defend Roe against Wade. But the other things, health care, a minimum wage, employment, housing, those are not issues in which you invest political capital in the courts. In fact, on the contrary, you'd be so busy fighting those battles that you don't pick a fight about the court, the same way President Clinton did. As far as the global war on terror, I actually at one point when I was thinking about this question thought that would be a testing case for the current generation of conservatives. And would you see the emergence of a kind of a robust, we're conservatives, but we still mistrust government, and we mistrusted whether it's engaging in economic regulation or the global war on terror. We still think the executive branch goes overboard. I sort of wondered, and you see that a little bit in the sort of the Cato Institute and some elements of the conservative movement. I wondered whether you would see that on the court. You don't. Now, Justice Scalia wrote an opinion in one of the early habeas cases which kind of reflected that view, but he doesn't seem to be there anymore. And certainly the two Bush appointees, not surprisingly given their biographies, that's not the way they're thinking about these issues. And not really the way anyone on the court is thinking about these issues, I don't think, but certainly not the way the conservatives are. So although at one point I would have thought, okay, the global war on terror, that's going to be a great testing ground for whether a certain form of coherent libertarian conservatism will emerge, I think we have our answer.
My question is about the intellectual leadership on the court. You said recently there hasn't been one. And I know there's some hypotheses that say the more intellectual and perhaps influential a candidate may be, the less likely they are to get appointed. Posner, Easterbrook, Wilkinson being three very popular examples. So my question is the political process kind of watering down the Supreme Court in terms of intellectual leadership, not to suggest that any of the justices aren't powerhouses. And then the second question is just the normative question of should there be an intellectual leader that kind of does have the chance to unify a court and institute an agenda?
Great questions. Related to the question this gentleman asked about whether the appointments process, as it's now constituted, systematically produces incoherence, because if you have a coherent view, you're too easy to attack. I think there is a lot to that at least in the current climate, people who have articulated a coherent view in their writings are big targets and are unlikely to get appointed for that reason. And there's also, underlying your question, the idea that, do we really want people on the Supreme Court who have this kind of, who talk like law professors, who say, well, here's my vision of what the court, do we really want that? And if you react against that by saying, no, I don't want that. I don't want some full of himself, egg-heady, intellectual, pseudo-intellectual, stuffed shirt, academic, jabberwocking guy deciding my cases. I hear you. But having said all of that, intellectual leadership doesn't necessarily come from intellectuals. The Warren Court actually was a great example of that. The two intellectual leaders of the Warren Court were Justice Black, who was a populist senator from Alabama, a politician before he was appointed to the court, and Chief Justice Warren, who was a tremendously successful politician, did not have an intellectual bone in his body. But what they had was instincts. They had a sense of what the court should be doing, of how they should be, what are we here for? They had a sense of that. And they couldn't not only couldn't write, they could, I'm going to go too far and say they couldn't even read a book, but that's not right. They would have the same reservations that you are, I think, expressing about the idea that we should have a vision. They say, I don't have a vision, I just do my job. But the way they conceived of their job expressed an idea of what they were there for. And that's what we're lacking. It doesn't have to be a vision articulated in the way that law professors articulate it. That's what we're here for. But it does have to be sort of an idea of, here's what I'm doing. And you see that in politicians. You see it in people who run for office. I'm not just running for office because I want the trappings of power. I want to get something done. That's the kind of thing. But it wouldn't be a political view. It would be a view, this is what judges are for. Judges are to stick up for the little guy, or judges are to protect individuals against the government, that kind of thing. You've sufficiently repressed all of your colleagues.
Sure. If you were going to just examine the Republican National Convention or the confirmation hearings of Roberts and Alito and the press around it, right, and just the way a detached observer would and say, what is the constitutional vision? What is the coherent constitutional vision? I don't think you have to be as crass and cynical as to say it's the platform of the Republican Party. There's all sorts of ways in which that's not true. But you could say something that's much more responsive to politics, that's less crass, that is more true, which is it is identified with outcomes, with views on certain issues, identity-defining conflicts, issues of personal and collective identity, race, abortion, guns, gays, the death penalty, separation of church and state. Right? So you start with the consensus of all the conservatives on the court, more or less, and much more than less, on how those kinds of cases ought to come out. And then you build a vision of American society, right, or a vision of where the country is or ought to be going out of that. It's not just the platform of the Republican Party. It's a lot of that. That's why people want, right, Roberts and Alito there. That's why people are so excited about Governor Sarah Palin, right, in the Republican Party. It's views on those issues. Now, you can say that may or may not be a good answer to the counter-majoritarian difficulty, right, and that's another whole issue. But it seems to me that's the obvious reality-based place to go in talking about what it means to be a judicial conservative today in terms of the people who care about them being there and are excited about it or who are very distressed about it.
Now, is the premise that there is a coherent view that can be built out of those issues as opposed to it being something that this particular coalition of interest groups endorses?
Right. It's not a premise so much as it raises a question. Are these just silos, just different issues, just like liberals have their own issues? Or is there a coherent vision that would tie them together, right? And it would be not just a vision of courts, but a vision of American society, right? One is much more religious, one is much more secular, for example, right? One is much more sort of gay people are part of we the people, right? No, they're not, or at least not entirely. You can't have the word marriage, right? You can have other things, but I think that's where now you may not be able to tie them together, but I think that's where you would go to find a conservative constitutional vision in terms of why people care about which justices are there.
Yeah. I mean, I guess there are a couple of questions. I mean, everything you say seems right to me. A couple of questions that you anticipate. One would be, can you really hold these together in a coherent view? Maybe. But even if you could, you would have the question of, as I said, why not? Fine. You have a party platform, win some elections. Why should it be judges who are implementing this view?
Thanks, David.
Thank you. Thank you all.